The HOA president threatened to have me arrested for trespassing on land my family had owned for nearly 70 years. And the worst part? She was standing on it too. I had driven to the eastern edge of the 2,000-acre property I had just inherited when I found something that absolutely should not have been there. A two-story clubhouse, a swimming pool, tennis courts, landscaped walking paths, and a parking lot packed with cars beneath a giant sign that read, Silver Creek Estates, residents only. For a few seconds, I genuinely wondered if I had somehow driven off my property. Then I spotted something beneath a hedge beside the parking lot, an old steel survey marker. I cleared the dirt away with my boot and looked at the parcel number stamped into the metal. My stomach dropped. It matched the parcel number on my probate deed. That was when a black SUV pulled into the parking lot. Patricia Holloway, president of the Silver Creek Estates HOA, stepped out with the property manager and a security guard. She didn't ask who I was. She didn't ask why I was there. She pointed toward the road and told me I had 5 minutes to leave before security called the sheriff. I told her there had been a misunderstanding. Then, I handed her my deed. Patricia glanced at it for maybe 3 seconds. Then she handed it back. This is HOA property. I told her the county records appeared to say otherwise. She actually laughed. Then she told the security guard to photograph my truck and license plate. Patricia warned me that if I returned to the clubhouse without permission, the HOA would treat it as criminal trespassing. I was standing there holding a deed with my family's name on it, and she was threatening to have me arrested. But Patricia wasn't finished. That afternoon, I received a formal trespass notice from the HOA's attorney ordering me to stay away from what they called their private recreational property. That's when I stopped arguing. I went home, locked my office door, and pulled up the county parcel records. At first, I thought I was reading the map wrong, so I checked it again. Then a third time. The boundary line didn't stop at the fence. It continued beneath the landscaping, across part of the parking lot, toward the pool. And then, I froze. Because if that map was accurate, Patricia had just threatened to have me arrested for entering a piece of land the HOA might have a very serious problem explaining. But I wasn't going to confront her with a computer screen. I needed something she couldn't laugh at. So I called a licensed surveyor. 2 days later, he arrived with his equipment and spent hours checking old monuments, county coordinates, subdivision records, and property descriptions. Patricia came outside halfway through the survey. She demanded that we leave. Then she threatened to call the sheriff again. This time, I didn't argue with her. I just watched the surveyor. Late that afternoon, he stopped near the clubhouse. He checked his equipment, looked toward the pool, checked it again. Then, he slowly turned toward me. The expression on his face had completely changed. He walked over and said quietly, "You need to call your attorney." I asked him one question. "How bad is it?" He looked back at the clubhouse, then at Patricia standing in the parking lot. And what he told me next was the moment this stopped being a simple property dispute. Because Patricia had spent the last 2 days trying to keep me off that land. She had no idea what the surveyor had just found underneath her entire community. I was 42 when my uncle Robert died and left me nearly 2,000 acres outside a growing Colorado suburb. To most people, that sounded like winning the lottery. From the outside, it looked like I had suddenly become a wealthy landowner with endless options. But the truth was a lot less glamorous. I worked in equipment management for a small construction company. My wife, Emily, and I lived carefully, paid our bills on time, and had never owned anything remotely close to a ranch that size. I did not inherit a luxury estate. I inherited miles of fence, aging access roads, tax obligations, irrigation issues, equipment that had not run in years, and a property history that stretched back through several generations of my family. Still, the land meant more to me than its market value. When I was a kid, Uncle Robert used to bring me there during summers. I learned how to repair fence posts, clear storm debris, drive an old tractor, and follow property markers across terrain that looked endless to a child. Robert was stubborn about one thing above all else: land boundaries mattered. He had watched developers buy up farms and ranches all around him as the nearby town expanded. Piece by piece, open land turned into subdivisions, gated entrances, landscaped medians, and communities with names designed to sound older than they really were. Robert refused to sell most of his property. The one major development that eventually appeared beside his eastern boundary was Silver Creek Estates, an upscale subdivision with large homes, manicured common areas, and a homeowners association that seemed to control everything inside its entrance. By the time I inherited the ranch, Silver Creek looked permanent. The clubhouse, swimming pool, tennis courts, walking paths, and parking area had clearly been there for years. Nothing about the place looked temporary, disputed, or improvised. That was exactly why I questioned myself before I questioned the HOA. After probate transferred the property into my name, I spent several weeks trying to understand what I had inherited. I reviewed tax bills, agricultural leases, old maintenance receipts, utility maps, and county parcel records. Most of it was boring paperwork until I noticed something unusual on the eastern boundary. The parcel map showed a rectangular section of my land extending towards Silver Creek Estates. At first I assumed it was a mapping error. County GIS systems are useful, but I knew they were not the final authority on a legal boundary. I compared the map to the deed description, then to an older plat I found among Robert's records. The shape was still there, and the deeper I looked, the more uncomfortable I became. That rectangular section appeared to overlap the same area where Silver Creek had built its recreational complex. I did not accuse anyone. I did not send threats. I emailed the HOA and politely asked whether they had a recorded easement, a lease, a purchase agreement, or some other document explaining their right to use that portion of land. Their response was vague. The property manager said the matter had been resolved years earlier and that the clubhouse was unquestionably part of the community. No deed was attached. No easement was attached. No lease was attached. That bothered me more than an angry response would have. If you have ever bought a home, inherited land, or dealt with an HOA, this is the kind of detail most people never think about until something goes wrong. A fence, driveway, trail, parking lot, or clubhouse can look permanent for years and still be sitting in the wrong place. If you have ever seen a property dispute like that, leave your thoughts in the comments, because what happened next made me realize how much confidence the HOA had placed in paperwork they had apparently never checked. I kept digging, and soon I found the first document that made me stop treating the boundary issue like a harmless map discrepancy. The document I found was not dramatic by itself. It was just an old county filing connected to the eastern side of the ranch. But it gave me enough reason to stop guessing and hire someone who could tell me exactly where my property ended. I contacted a licensed surveyor named Mark Ellison and sent him everything I had: the probate deed, the older plat maps, the county parcel information, and photographs of the steel marker near the Silver Creek clubhouse. Mark agreed that the records were unusual enough to justify a full boundary survey. That was when the HOA stopped being dismissive and started becoming aggressive. Before Mark had even finished scheduling the fieldwork, I received a letter from an attorney representing Silver Creek Estates. The letter warned me not to interfere with what it called established community property. It claimed the HOA had exercised control over the clubhouse area for many years and suggested that any attempt to disturb landscaping, restrict access, move markers, or interrupt community operations could expose me to legal liability. The language was polished, but the message was obvious. They wanted me intimidated before I learned where the line actually was. I forwarded the letter to Mark and told him to continue. A few days later, his crew arrived with GPS equipment, metal detectors, measuring instruments, and copies of recorded plats. Their job was simple in theory: locate the established monuments, compare them to the legal description, and reconstruct the boundary using the official record. Silver Creek made even that difficult. Within an hour, an HOA security employee approached the crew and told them they could not enter the landscaped area near the clubhouse. Mark explained that he was working for the recorded owner of the adjoining parcel and needed access to several points required for the survey. The security employee contacted Patricia. She arrived not long afterward with the property manager and immediately treated the survey itself like an act of trespassing. She insisted the HOA owned everything from the decorative subdivision monument to the creek and ordered Mark's crew away from the parking lot. I drove over when Mark called me. By the time I arrived, the atmosphere had changed completely. The property manager was photographing our vehicles. Security was documenting the survey equipment. Patricia had already contacted local law enforcement. A sheriff's deputy arrived expecting what probably sounded like a routine trespassing complaint. Instead, he found two competing claims and a licensed survey crew standing beside recorded property documents. I showed him my deed. Mark showed him the plat references he was using. The HOA could produce rules, community maps, and internal documents, but nobody standing there produced a recorded deed showing that the disputed section had ever been transferred out of my family's ownership. The deputy made it clear that he was not going to decide a civil title dispute in a parking lot. Nobody was arrested. Nobody was removed. Mark resumed his work. That should have been the moment the HOA slowed down and checked its records. Instead, they escalated. The next morning, I received another notice. This time, Silver Creek claimed that temporary survey stakes and field markings near the common area required HOA approval. They assessed me a $1,750 architectural and compliance charge for unauthorized activity affecting community property. I read the notice twice because I thought I had misunderstood it. The HOA was trying to fine me for surveying land I might already own. Then, things became public. An email went out to Silver Creek homeowners describing me as an outside land speculator challenging long-established community amenities. The message warned residents that access to the clubhouse and pool could be threatened by what it called an opportunistic boundary claim. Within days, homeowners started discussing me online. Some assumed I wanted to shut down the pool. Others accused me of trying to force the neighborhood into paying me money. A few people drove slowly past the ranch entrance and took pictures. Someone left a note on my gate accusing me of trying to steal property from families who had paid HOA dues for years. That was the point when the situation became personal. I had inherited land from a man who had spent most of his life refusing to let developers pressure him into selling. Now I was being portrayed as the person trying to take something away. For one evening, I came close to responding publicly. I wanted to post the deed. I wanted to upload the county map. I wanted every homeowner to understand that I had not walked into their subdivision claiming random land. Emily talked me out of doing anything impulsive. The next morning, I contacted a real estate attorney named Rachel Kim. I sent her the HOA letters, the fine, my deed, the survey information, the homeowner email, and every document I had found. Her advice changed the way I handled everything from that point forward. I stopped answering emotionally. I saved every email. I photographed every notice. I backed up the security footage from the ranch entrance. I created folders for county records, HOA correspondence, survey documents, tax statements, and old family papers. I documented dates, names, and every attempt to interfere with the survey. I did not touch the clubhouse. I did not block the road. I did not remove a single HOA sign. And I did not argue with homeowners online. While Silver Creek was telling hundreds of people that I was making an outrageous land grab, Mark was quietly finishing measurements that would settle the most important question in the entire dispute. When he called me several days later, his voice was careful. He said the survey was not showing a minor overlap. It was showing something large enough that he wanted to verify every monument again before putting his seal on the final drawing. That was the moment I realized this was no longer about a marker hidden under a hedge. If Mark's preliminary work was correct, the HOA had spent years treating a substantial piece of my ranch as if it belonged to them, and somewhere in the county records, there had to be an explanation for how that happened. Mark did not send me the final survey that afternoon. He told me he wanted to recheck 2 monument locations, compare them against an older recorded plat, and verify the coordinates against county control points before putting his license behind the result. That made me nervous. Not because I thought he was wrong, but because professionals do not slow down like that unless the answer matters. While he verified the fieldwork, Rachel started building a paper trail from the other direction. She told me that property disputes were rarely won by whoever sounded more confident. They were won by records that survived scrutiny. So instead of arguing about what the HOA believed, we focused on what had actually been recorded. I went through every box Uncle Robert had left behind. Old tax statements, handwritten maintenance notes, farm leases, utility correspondence, fence repair receipts, county notices, maps folded so many times the paper had gone soft along the creases. Rachel requested certified copies of the chain of title for the Eastern Tract. She also pulled subdivision plats for Silver Creek Estates, recorded easements, development agreements, planning documents, and every public filing she could connect to the clubhouse property. Then we looked at permits. That was where the timeline started becoming strange. The clubhouse had been permitted years earlier as part of a later phase of Silver Creek's development. The permit packet included a site plan showing the recreational complex comfortably inside the subdivision boundary, but the recorded plat did not line up the same way. The difference was not obvious unless someone compared the documents side by side. On the permit drawing, the eastern property line appeared farther out. On the recorded plat, it sat farther west. That single shift was enough to swallow the pool, part of the parking lot, and a large portion of the clubhouse complex. Rachel did not jump to conclusions. A permit drawing could be inaccurate without proving ownership. A GIS map could be wrong. An old survey could be superseded. A recorded easement might exist under a different legal description. So we kept looking. The county assessor records showed something even more important. For years, the Mercer family had continued paying property taxes on the disputed acreage. There was no obvious split. No transfer of those acres to the HOA. No deed recorded under Silver Creek Estates. No quitclaim deed. No purchase agreement that had been recorded as a conveyance. Nothing that explained why the HOA believed the land belonged to them. Then Mark called. His final survey was complete. I met him at his office with Rachel. The drawing was spread across a conference table, covered with bearings, distances, monument references, and notes that meant very little to me until Mark traced the eastern boundary with his finger. The result was worse than his preliminary estimate. Roughly 6.4 acres of the Silver Creek recreational complex fell inside my parcel. The clubhouse itself crossed substantially onto my land. The pool sat inside it. More than half of the parking area did too. A section of landscaped common space and part of the access route were also affected. This was not a fence built 18 inches over a line. It was an entire amenity complex. Rachel asked the question I had been avoiding. How had anyone built all of that without obtaining the land first? That sent me back into Robert's boxes. For 2 nights, I went through everything again. On the 3rd night, I found a thin folder labeled with the name of the developer that had originally built Silver Creek. Inside was an agreement I had never noticed before because the title sounded harmless. Temporary Construction Access Agreement. The document was nearly 15 years old. According to the agreement, Robert had allowed the developer to use a defined portion of his eastern property for construction access, equipment staging, and temporary material storage, while Silver Creek was being built. The permission lasted 24 months. That was it. The language was unusually clear. No ownership interest was transferred. No permanent easement was granted. No right to construct permanent improvements was created. And the access terminated automatically at the end of the stated period unless both sides signed a written extension. We searched for an extension. There was none. We searched for a later deed. None. We searched for a ground lease. Nothing. For the first time, the history of the dispute started to make sense. The developer had once been legally allowed onto Robert's land. That temporary access may have made the area feel like part of the development during construction. But temporary permission was not ownership. Somewhere between the early construction phase and the completion of the clubhouse, that distinction appeared to have been ignored. Rachel immediately requested older planning files and archived correspondence connected to the developer. At the same time, I sent the HOA a formal written request asking them to identify the exact recorded instrument they relied on for ownership or permanent use of the 6.4 acres. I gave them the parcel description. I referenced the certified survey. I asked for the deed, easement, lease, boundary adjustment, or other recorded document that supported their claim. Their response arrived through the property manager. They did not provide a deed. They did not provide an easement. They did not provide a lease. Instead, they insisted the community had used the clubhouse property continuously for years and demanded that I stop interfering with HOA operations. Patricia followed with another message accusing me of harassing the association through repetitive document requests. I saved both emails. Rachel did too. The next discovery came from a place I did not expect. One of Robert's old tax folders contained a photocopy of a letter from the original developer. It referred to the temporary access area and thanked Robert for cooperating during the early phase of construction. The date was several years before the clubhouse was finished. That meant the developer knew exactly who owned the ground during at least part of the project. We still did not know whether the clubhouse had been placed there through negligence, bad surveying, bad paperwork, or something more deliberate. But we knew one thing now with much greater certainty. The HOA could not answer the simplest question in the entire dispute. If this land was really theirs, where was the document that gave it to them? Rachel told me not to threaten anyone yet. She wanted one more round of records. Archived county planning correspondence, original site plan revisions, and internal documents from the period when the recreational complex had been approved. Because if someone had raised the boundary issue before construction and the developer had ignored it, this case was about to become much more dangerous for Silver Creek than the HOA understood. The archived planning records changed everything. Rachel had requested every document connected to the clubhouse site, including early engineering notes, subdivision revisions, and correspondence between the original developer and the county. Most of it was routine: drainage calculations, landscaping comments, utility approvals, setback measurements. Then she found an email buried in an old project file. It was from an engineer working on Silver Creek during the development phase. The message was short, but one sentence stood out immediately. The Mercer Tract boundary needed to be resolved before any permanent improvements were built near the eastern edge. That meant someone had noticed the problem before the clubhouse was finished. More importantly, the warning had not come from my family. It had come from the developer's own side. Rachel printed the email and placed it beside the temporary construction access agreement. Together, the documents told a much more serious story. The developer had permission to use Robert's land temporarily. The developer knew the boundary required clarification. The temporary agreement did not transfer ownership, and yet permanent improvements were later built in the same area. That was the point where Rachel stopped treating the case like a simple survey disagreement. She prepared a formal demand letter. It was not emotional. It did not accuse Patricia of theft. It did not threaten to bulldoze the clubhouse or lock homeowners out of the pool. It simply laid out the facts. The certified survey placed approximately 6.4 acres of the recreational complex inside my parcel. The chain of title showed no recorded transfer of those acres. The temporary construction agreement had expired years earlier. The agreement specifically denied any transfer of ownership interest and granted no permanent easement. The county records showed my family had continued paying taxes on the land. The HOA had been unable to identify any deed, lease, easement, or boundary adjustment supporting its claim. And now we had evidence that the original developer had been warned about the unresolved property line before permanent construction was completed. Rachel gave the HOA 3 possible paths. They could negotiate a purchase of the affected acreage. They could enter into a long-term ground lease that legally allowed the clubhouse and related improvements to remain. Or they could prepare to remove the structures and restore the property if they insisted they had no obligation to compensate me. That was when Patricia made her biggest mistake. Instead of taking the letter seriously, she treated it like a bargaining tactic. Through the HOA's attorney, Silver Creek offered a small one-time payment in exchange for me releasing all claims connected to the boundary. The number was so low that it did not even cover what I had already spent on legal work, surveying, and title research. Rachel advised me not to respond immediately. We hired an independent commercial appraiser instead. The appraiser looked at the land differently than I had. To me, it was ranch property. To Silver Creek, those 6.4 acres were the physical foundation of one of the most important amenities in the entire subdivision. The clubhouse supported community events. The pool was part of the neighborhood's marketing value. The parking area served residents and guests. The recreational complex was tied directly to the HOA's operations and the perceived value of homes around it. Replacing it somewhere else would require new land, new permits, new construction, new utilities, and years of disruption. The land had strategic value far beyond ordinary acreage. When the appraisal came back, Rachel used it to calculate a proposed commercial ground lease. The annual rent was close to 5 times what the HOA had informally suggested paying. Then she added another issue: past use. For years, the HOA had collected dues and fees while using property it had never purchased. Rachel believed we had a credible basis to demand compensation for unauthorized use, along with reimbursement for survey costs, title research, and attorney fees. Patricia called the proposal outrageous. The HOA accused me of trying to exploit homeowners, but their position had become weaker with every document we found. Then another piece of evidence surfaced. Rachel tracked down a former Silver Creek board member who had served years earlier, long before Patricia became president. He remembered the boundary problem. According to him, The board had been told there was uncertainty involving the Mercer property during discussions about the clubhouse area. The issue had been treated as something the developer would eventually resolve. But after the developer transferred control of the association to the homeowners, nobody wanted to spend money reopening the problem. The clubhouse was already standing. Residents were already using it. And the easiest thing to do was to assume that time would make the issue disappear. It did not. Time had only made the consequences more expensive. Rachel documented the former board member's statement and sent a supplemental notice to the HOA. This time, the tone of their response changed. The confident threats disappeared. The accusations became shorter. The HOA attorney requested additional time to review historical records. Their insurance carrier asked to be notified. Patricia stopped emailing me directly. For the first time since the dispute began, Silver Creek was no longer telling me to prove that the land was mine. They were trying to prove that it was theirs. And they still had no deed. No permanent easement. No lease. No recorded transfer. The only written permission we had found was a temporary agreement that had expired more than a decade earlier. That was the moment the balance of power finally shifted. I had spent weeks being called a trespasser on my own property. Now the HOA had to explain why a multi-million-dollar community complex was sitting on land they could not prove they owned. And once the county and the insurance company started asking the same question, Patricia could no longer control the story. Once the insurance carrier became involved, Silver Creek could no longer treat the dispute like a private argument between an HOA president and a landowner. The carrier wanted documents, not explanations, not community newsletters, not Patricia's opinion about what the HOA had always believed. They wanted deeds, easements, surveys, board minutes, permit records, development agreements, and every historical file connected to the clubhouse. Rachel forwarded our certified survey, the temporary construction agreement, the tax records, the archived engineer email, and the former board member's statement. At almost the same time, the county planning department began reviewing the original clubhouse file. The county was careful not to declare who legally owned the land. That was a title issue, and everyone understood that a court could ultimately be asked to decide it. But county staff could compare recorded plats, permits, and current survey information. What they found was enough to create another problem for Silver Creek. The current certified survey matched the recorded boundary monuments far more closely than the site drawing used during the clubhouse permitting process. If that boundary controlled, parts of the clubhouse complex were outside the parcel identified in the old permit application. That meant setback calculations, site assumptions, and several improvements had been approved using information that did not reflect the actual ownership line. A code enforcement inspector visited the site. I did not go with him. Rachel advised me to stay out of the inspection process completely. The inspector photographed the clubhouse, the pool area, retaining features, utilities, fencing, parking spaces, and the locations marked on Mark's survey. Within days, the HOA received written notice that the county was reviewing the historical permit file and that additional documentation would be required. That was when the atmosphere changed inside Silver Creek. Homeowners who had been told I was an opportunistic outsider started asking a much simpler question. Why could the HOA still not produce a deed? A special board meeting was scheduled in the clubhouse itself, the same building I had once been ordered to leave. I attended with Rachel and sat near the back. Patricia was at the front table with the remaining board members, the property manager, the HOA's attorney, and a representative connected to the insurance claim. The room was packed. Residents stood along the walls. The tone was nothing like the confident emails I had received weeks earlier. The HOA attorney explained that the association faced several possible outcomes. If the title issue went into litigation, legal fees alone could become substantial. If Silver Creek lost, it might have to negotiate continued use of the land, purchase it, pay damages, or remove improvements. If the county determined that parts of the site required corrective permitting or other compliance work, that could create additional costs. And if insurance coverage did not apply to every part of the dispute, homeowners could eventually face a special assessment. That last phrase changed the room instantly. A special assessment meant this was no longer somebody else's problem. Residents began asking how the HOA had spent years operating a multi-million-dollar amenity on land it could not prove it owned. One homeowner asked why legal fees had already been spent threatening me instead of verifying the property records first. Another asked whether previous boards had known about the Mercer boundary concern. Patricia tried to frame the situation as an old technical dispute being exploited by a new owner, but the explanation no longer worked. Rachel did not argue with her. She simply provided copies of the recorded deed, certified survey, and expired temporary agreement to the board's attorney. There was nothing dramatic about the gesture. That was what made it so effective. For weeks, Patricia had relied on authority, confidence, and the assumption that the HOA's long use of the clubhouse made its claim legitimate. Now every important person in the room was looking at documents instead of listening to her. The insurer wanted proof. The county wanted accurate records. The HOA attorney wanted to reduce exposure. The homeowners wanted to know whether their dues were about to increase. And the board wanted to know how badly the situation could get. By the end of the meeting, Patricia was no longer directing the conversation. The attorney was. He requested permission from the board to enter formal settlement negotiations. The motion passed. A few weeks earlier, the HOA had fined me for putting survey stakes near the clubhouse. Now they were asking my attorney what it would cost to keep the clubhouse where it was. And that was the moment I knew the dispute had reached its real turning point. The question was no longer whether Silver Creek had a problem. The question was how much that problem was going to cost them. The settlement took several more weeks, but by then the argument was no longer about whether Silver Creek had a problem. It was about which solution would hurt the least. Removing the clubhouse was technically possible, but financially brutal. The pool, utilities, parking area, landscaping, retaining work, and access improvements were all tied into the same site. Relocating the complex would have meant finding new land, securing permits, redesigning the facility, and asking homeowners to absorb the cost. Buying the 6.4 acres outright was not much easier. The HOA did not have enough cash on hand to make a clean purchase without either financing the deal or imposing a major assessment. So they came back to the option they had mocked at the beginning: a ground lease. Rachel negotiated every term carefully. The final annual rent was nearly 5 times the amount Silver Creek had originally tried to suggest when they still believed I would accept a token payment and disappear. The agreement also included a separate settlement for past unauthorized use, reimbursement for the certified survey, title research, and a large portion of my legal expenses. The $1,750 HOA charge against me was canceled. The trespass notice was withdrawn. The association formally acknowledged that the disputed acreage was not part of the HOA's recorded ownership. In exchange, I agreed not to interfere with normal clubhouse operations as long as Silver Creek complied with the lease. I did not lock the gates. I did not close the pool. I did not try to punish hundreds of homeowners for decisions made by a developer and years of careless board management. I simply made the HOA pay legally for land they had been using as if it were free. The political fallout inside Silver Creek was almost immediate. Patricia announced that she would step down as president before the next board election. 2 other board members chose not to run again. Homeowners demanded tighter controls on legal spending and new procedures for reviewing property documents before the association approved major projects or made threats against residents and neighboring landowners. The new board adopted a policy requiring certified boundary verification, title review, and written easement documentation before any major construction near the edge of HOA property. What had started with Patricia accusing me of trespassing ended with the HOA changing its own rules because nobody wanted another disaster like this one. The strangest part was returning to the ranch after the settlement was signed. Nothing looked different. The clubhouse was still there. Children were still using the pool. Cars were still parked in the same lot. But legally, everything had changed. Silver Creek was no longer pretending the land belonged to them. They were using it because I had given them written permission under terms that protected my ownership. The first lease payment helped me repair one of the ranch roads Robert had neglected near the end of his life. I also replaced fencing along the northern pasture and set aside part of the settlement money for long-term maintenance. I never became the land speculator the HOA had warned everyone about. I kept the ranch. I kept the open ground. And I kept the promise I had made to myself after inheriting it. I would not let someone else decide where my property ended just because they had more confidence, more paperwork with their logo on it, or a boardroom full of people willing to repeat the same claim. Uncle Robert had spent years telling me that property lines mattered because memory faded, people changed, and promises disappeared. Records did not. That lesson ended up being worth more than the lease. I did not win because I shouted louder than Patricia. I did not win because I threatened the HOA. I won because I kept the emails, ordered the survey, checked the deed, followed the county records, found the expired agreement, and let the evidence do the work. And that was the part Silver Creek never expected. If you think I handled it the right way by protecting the property without punishing the entire neighborhood, leave your opinion in the comments. If you have ever dealt with an HOA, boundary dispute, easement problem, or someone who acted like they owned land they could not prove was theirs, share this story with someone who needs to hear it. Save the video if you want to come back to it, and subscribe for more stories where patience, paperwork, and property rights end up being stronger than intimidation. Because sometimes the most satisfying revenge is not revenge at all. It is making people respect the boundary they should never have crossed.